Good afternoon, everyone. First, allow me to introduce myself. I am Raul Bautista Villanueva, Deputy Court Administrator of the Supreme Court. Well, I used to be an RTC judge in Las Piñas City. I served in the bench for more than 7 years before joining the office of the Court Administrator, which is considered as a promotion, no? In terms of rank, because per law, my rank is that of an Associate Justice of the Supreme Court. Anyway, I'm here because of the invitation by the Legal Education Board, particularly by Commissioner Sorera T, who sent me a letter regarding this modular clinical legal education training program that the Legal Education Board is holding in connection with the implementation of the revised Rule 138A of the Rules of Court, among others. So it is my distinct honor and pleasure to actually be one of the lecturers for this particular modular training program. So before I do that, I hope you don't mind. It's really difficult to give a lecture online as far as, well, based on my experience, considering the fact that a lecturer just keeps on talking and talking, and of course, not even knowing, how the participants are actually reacting, no? Or more or less if they are learning, no, from what is being shared to all of them. But I do hope that, considering that my topic is a very simple one, I trust that this will be a session which will just give you some ideas, no, on how law student practitioners should be treated, no, when they appear before courts. Of course, it might not cover as many, situations as we would want to, but hopefully at least by giving this lecture, you would be able to at least help out, no? Our law student practitioners, and of course our law student practitioners would also be aware of more or less the limitations, restrictions, and of course the extent, no, of the authority that is being given to them. So magandang hapon sa inyong lahat, or magandang araw sa inyong lahat. I'm recording this particular lecture in my office. So I hope one way or the other what I will be presenting to all of you is something that will be useful, and at the same time will be clear. And of course, you would be able to follow, no, what I will be sharing with all of you. So it's judicial attitude towards law student practitioners. I would expect that there would be lecturers who would be discussing in detail what the law student practice rule is all about, particularly the revised Rule 138A of the Rules of Court. So I will not go into the details insofar as the provisions, no, of this particular rule is concerned. I will just like to zero in, of course, just by way of reminder, what are the certifications that will be issued in connection in order to allow our law students to practice, no, before our courts or before other tribunals or bodies wherein their legal skills or knowledge may be required. First is the Level 1 certification, which briefly, is issued for law students who have completed their first year law courses. So that means it's only being issued to second year law students. Based on our amended rules right now, it is the RTC Executive Judge, where the law school, which has a jurisdiction over the law school where it is located. So if, for example, in my case, there is a law school in Batangas State University, then the RTC Executive Judge of Batangas City will be the one who will issue that Level 1 certification. The Level 2 certification is being issued for law students who have already finished their third-year law studies, particularly they're up to their first SEM third-year law studies. So this means this can only be issued during the second semester of a third-year law student. And take note that the RTC Executive Judge will not be the one who will be approving such level 2 certification, but actually it's the Office of the Court Administrator. And in the case of law schools located from in regions 1 to 5, that will be my office, no, as Deputy Court Administrator for Luzon. So that is what I would just like to more or less remind you of, because this level 1 and level 2 certifications actually are not just issued to our law students simply because they would want to, but they have to qualify, you know, insofar as these certifications are concerned. But what I would just like to emphasize that with respect to level 1 certifications, the validity is only with respect to courts, quasi-judicial and administrative bodies within the judicial region where the law school is based. So meaning the law student who is given a level 1 certification can only appear in our courts or assist any litigant under their clinical legal education program in courts within, for example, in the case of Batangas, within the 4th Judicial Region. So take note. So it's limited only to those courts in those located in Region 4. With respect to level 2 certifications, they can be valid before all courts, quasi-judicial and administrative bodies, even outside the judicial region where the law school is based. So that means the law student who was given a level 2 certification can actually appear before courts outside of Region 4. So they can go to Region 5 if there's a case that they need to attend to, or they can even go to Region 3 or even in the National Capital Region, so long as it's a level 2 certification. And how does level 1 certification look like? Portrayed or shown in our Supreme Court resolution. So that's the format, a level 1 certification. So the name of the student is indicated, and of course the name of the law school and the certification number is indicated. I already showed to you a level 2 certification, which this is an actual one that I issued. So it involves a law student of the Batangas State University, located in Batangas City, Batangas. So more or less, you can see that aside from the name, it also mentions the law school, and of course, the approval is based on our office's evaluation of the endorsement and the supporting documents submitted by the executive judge of the Regional Trial Court of Batangas City, who happens to be Judge Maria Cecilia Austria Chua. So that is how it looks like. So this particular law student, like I mentioned, can actually appear not only in Batangas, not only in Quezon, which is in Region 4, not only in Laguna or in Cavite, but also outside of the 4th Judicial Region, because it is a level 2 certification. So let me now go to the meat of my presentation, which is actually to just give you an idea on how this law student practitioners should be treated, not only by our judges, but also by our lawyers or members of the bar. So first, they have to respect the certification. So please take note that if you do not respect the certifications, you disregard or you do not recognize these certifications, then one way or the other, to my mind, you are not providing what our law students need, and that is a little mentoring insofar as recognizing what should be respected insofar as practicing before our courts or quasi-judicial bodies are concerned. Para sa akin, basic talaga yan that the level certifications, levels 1 and 2 certifications should be respected because that's where everything starts. No? Because the moment that they appear, actually the law student will appear and of course the basis of his appearance is the certification. So among others, aside from of course being recognized as a law student who is part of a clinical legal education program of a particular law school. So pinaka-importante yan, respeto, ika nga, sabi nga nila. So please take note that of course, I hope that there should be no issue regarding the authenticity of any level 1 or level 2 certification. But in the event that the lawyer, the opposing counsel would want to just make sure that these are valid and authentic certifications, then they can ask for such confirmation, of course, from the issuing regional trial court, if that is what they want, or even our office. Please take note that insofar as the certifications issued by the executive judges, we do not have files on this, but we have files with respect to the level 2 certifications that we are required to issue. So you can always get in touch with us if you have any query with respect to level 2 certifications coming from regions 1 to 5, for regions 1 to 5. So just for the record, you can get in touch with our office. My office is the landline number is 8524-5981. So 8524-5981. I'm giving these numbers just so that if you want to just check on this on the authenticity and the validity of these level 2 certifications coming from my office, then that's the number that you can call. Next is that, when you respect the certifications, you also have to recognize now that these law students are officers of the court. So the judge should treat a law student as an officer of the court, and of course the lawyer, the opposing counsel, should likewise do the same. What is the reason? The reason is so that everyone should understand that an officer of the court has responsibilities, not only to the court, not only to the lawyer, not a fellow lawyer, but also to to society, and of course to the client, that this law student practitioner is representing. So that's very important that together with this certification being given to our law student practitioners is, of course, the responsibility being an officer of the court. So it cuts both ways. So hindi pwedeng sabihin na pag nirecognize na siya na officer of the court, ay he can just do about anything. That is not correct. In fact, now we can consider them as bound by our Code of Professional Responsibility, although to a limited extent because they're not yet members of the bar. Likewise, we ask everyone, especially our judges, not only our practitioners, that they should be patient, insofar as our law student practitioners are concerned. Why? Because obviously, they do not have yet a mastery of the law, even the rules and jurisprudence. Of course, we expect them to always be prepared. These law student practitioners, every time they appear before our courts. But in the event that to a certain extent they fail to exhibit their mastery of these rules and jurisprudence, especially now because we have so many rules that have been amended. For example, the rules on civil procedure, which became effective only last May 1 last year, May 1, 2020. Even the rules on evidence also effective last May 1, 2020. So, and of course, there are other rules that are being implemented, even with respect to video conferencing. We now have the proposed guidelines, no, for the conduct of video conferencing hearings. So they might not be able to fully grasp all of these particular rules. So be a little patient and understanding with respect to any deficiency that they may be exhibiting. So patience is a virtue, sabi nga nila. So, but of course, being patient doesn't mean that you have to coach or you even have to, keep on, trying to baby, these law student practitioners. The point is just there might be some oversight, that you can just point out without making them pay, because of these technicalities. So I hope, especially when they're appearing before our courts, patience is something that we all must have in abundance, so to speak, insofar as our law student practitioners are concerned. Likewise, do not bully them. Kawawa naman, no? I'm sure sometimes when we see a young lawyer practicing, we have this tendency to belittle their ability, no? And more so with the law student, sort of bullying them, into submission. So please do not do that. The judges and even the lawyers are there to help them understand better, how we conduct our proceedings. So please, you're not supposed to lord over them. Okay. Next is, of course, you can provide tips or suggestions. It's like mentoring them, but that's perhaps for our judges more than for our lawyers, because the lawyer, of course, has his own agenda insofar as appearing for his client is concerned, and we can understand that. They don't have to come up with any suggestions or tips, but our judges, we want to keep on reminding them that that's something that they need to do when it comes to our law student practitioners. If they feel that there is something that needs to be shared, with them, especially when they're appearing without their supervising lawyer. Although most of the time they're expected to be there, but there might be instances where the supervising lawyer is not around. So, you can always, especially our judges, should be able to at least provide some useful tips for them, okay? In order to, of course, improve their skills as future law practitioners. And I'm sure they will appreciate it more if that is done, rather than, they are not being told anything at all, and then you would want them to just find things on their own, find out things on their own, which is, if you can provide it already right then and there, then you should. I'm referring to our judges now when it comes to those kinds of situations. Likewise, you have to encourage and not discourage them. Kawawa naman. Can you imagine, these are law student practitioners, and then you belittle them. Instead of encouraging them, after that hearing, they might end up, dropping entirely, from the course, or even stopping in pursuing further the law studies. That is not the intention of, this law student practice rule. The intention really is to encourage our law students. They should be inspired to further finish the course, so to speak, so that they would have that opportunity to become full-fledged members of the bar. So that is something also that our judges should keep in mind, and of course our lawyers should also take into account when they are appearing as against or with the law student practitioner as the opposing counsel. Finally, of course, you have to remind them of their duties. Like I said, as officers of the court, they're bound by, to a certain extent, they're bound by our, and covered by our Code of Professional Responsibility. So it pays also to remind them of their responsibilities. So that's a reason why I included in my presentation some of these of course, canons of the Code of Professional Responsibility by way of a reminder, because the lawyer appearing before our courts, who may have as opposing counsel a law student practitioner, should always take into account that he should be treated as an officer of the court, as a lawyer, short of being a lawyer, and so much so that we have to make sure that the canons of the Code of Professional Responsibility are always, they always come into play. So I placed or included, at least some pertinent canons. Canon 7, which is of course to uphold the dignity, integrity of the legal profession. Canon 8, to conduct, lawyers should conduct himself with courtesy, fairness, and candor toward these colleagues. And of course, Canon 9, lawyers shall not directly or indirectly assist in the unauthorized practice of law. For this particular canon, what I am thinking of is, of course, we should not, this situation wherein we take advantage of these law student practitioners. So please take note. They're not there to be taken advantage of, meaning sometimes there might be a situation wherein some of our law firms may be using, might have this program, clinical legal education program, which may be accredited or which may be allowed, even on a limited scale, wherein law students may be used in order to further advance, not in a good way sometimes, the cost of the law firm itself. So just take note. Again, I will not go into the details of these canons. They're there to just remind our lawyers that when they appear, and they have a law student practitioner as, like I said, and I keep on referring to as opposing law student practitioner, then they have to make sure that the canons always are relevant insofar as this case with respect to their engagement is concerned. So but when it comes to our judges, of course, I have to remind them every time they have to deal with our law student practitioners that, of course, they have to exhibit the kind of judicial conduct that is expected of them. In other words, the judicial conduct that they should be showing to our law student practitioners should not be different with respect to the kind of conduct that full-fledged lawyers are supposed to witness when it comes to our judges. So it should always be the same. There should be no discrimination. There should be no, change in the judicial conduct. It should always be the same. So the independence of the court should be known to our law student practitioners. The integrity of the presiding judge should always be upheld. Insofar as the impartiality, this should be evident and seen, and felt and known to the law student practitioners. The propriety with which they conduct themselves, both inside and outside of the court, especially with respect to their activities outside of the court, it should also, this is something important that the law student practitioner should be aware of as well. And of course, like I said, we do not promote discrimination, oppression, or favoritism. That's why everybody should be treated equally. You should not favor a lawyer as against a law student practitioner simply because of their standing as such. That should not be the case. And of course, the judges should not be sloppy. They should not. They should show to our law student practitioners how diligent they are, how competent they are insofar as their judicial work is concerned. So again, there are The canons are there only not for detailed discussion, but just a reminder that the judge, when it comes to our law student practitioners, should not distinguish these kinds of practitioners as against, in comparison with the full-fledged members of the bar. Because what is expected of them is to make sure that no one is treated differently every time there is an appearance made before their courts. So I come now to more or less a discussion of some of the cases before I end on why judicial attitude is very important, because we have a number of cases already wherein the judges, erring judges, are actually penalized for misbehavior. The first case I would like to discuss is this case, anonymous complaint. This anonymous complaint dated February 18, 2005, of a court personnel against Judge Francisco Gedonio Jr. Of RTC or Moc City. In this particular case, the complainant actually alleged that the judge keeps on shouting and reprimanding lawyers appearing before him. But not only that, even the personnel and the witnesses and litigants. So everybody, parang lahat na lang, parang hindi magaling sa kanya at siyang pinakamagaling. So and he has a short temper and uses intemperate language and embarrasses lawyers and litigants alike. And of course, he was quoted in that complaint to be using, words like puñeta, or sometimes referred to one of his staff as bakla or animal. So that's the reason why there was a complaint, because very abusive na yung judge. The court actually decided in this particular case that insulting and of course insensitive expressions such as puñeta, animal, bakla, and bullshit is a language not befitting a judge. Obvious naman yun, because you're not supposed to do that, whether during the conduct of the trial or even while there is no hearing and then you're just outside your staff room. You're just at the staff room. The point is, this is not something that you should be doing, a judge, for that matter. Likewise, judges should always be temperate, patient, and courteous. So one of the things I ask, of course, the judicial conduct or attitude among our judges is patience. So obviously, our judge, the respondent judge here, was not the patient kind. That's why he burst and utters these kinds of intemperate language or words. And the court also said that judge behavior must be beyond reproach, being the visible personification of law and justice, meaning whether inside or outside, like I mentioned, they have to make sure that everything they do is measured in a way. Talagang mahirap pag maging judge, because I should know, because I used to be a judge, like I said earlier, because we need to make sure that we're able to live up to the standards required of us. And it's a very high standard, because we have two codes that we need to comply with. First, the code of professional responsibility, because as a judge, we're still lawyers, first and foremost. And then, of course, second is the code of judicial conduct, because we are members of the bar already, or members of the bench already. So quiet dignity, self-restraint, and temperate language are expected of every judge. So I hope the judges who are part of this particular training program would understand that and would realize that that is what is expected of them. And of course, for our lawyers or even the law students who are listening, hopefully this is something that would remind all of you that if we require something from you, we require also something from our judges, and vice versa, so to speak. So in this particular case, the judge who was actually found guilty of conduct unbecoming of a judge was fined the sum of 5,000 pesos. Next case is Juan de la Cruz versus Judge Ruben Caretas of RTC Legazpi City. Practically the same allegations with some, of course, additional ones. So this judge is also arrogant and insults through side comments, witnesses, lawyers, and the prosecutors. So kumbaga sa hindi niya mapigilan yung sarili niya to come up with comments every time he feels like doing so. And then he interferes in the presentation of witnesses and asks more questions as compared to even the lawyers. So in other words, practically showing more interest, as if perhaps lawyering even for one party over the other, which should not be the case. So in fact, because of his attitude, the Office of the Provincial Prosecution decided not to assign a prosecutor in his court. So can you imagine it went to that point already. So the court, so far as this case is concerned, ruled that for one, a judge should possess the virtue of gravitas. So dapat medyo with dignified humility, parang ganun, medyo humble ka naman. Wag naman yung parang di ba? Sobrang yabang na ang dating, So the court said that it is reprehensible for a judge to humiliate a lawyer. So like I said, do not paano yung pag-humiliate ng lawyer hindi na nga pwede. Paano pa kaya kung law student practitioner yan, So please take note that this applies even more, to our law student practitioners, So at mas mahirap pa yung yung epekto noon, like I said. Baka naman hindi na magtuloy yan, matroma pa yan, ayaw na maging abogado, baka gusto nila maging doktor, So so it's a loss, to our profession, so to speak. And the dispensation of justice is a joint responsibility of the judge and the lawyer. So take note. While lawyers and even now law student practitioners appear before us, as part of proceedings and to dispense with justice, but this is a responsibility of everyone, which includes also the law student practitioners. So that means that you cannot, kumbaga leave them out, the law student practitioners, more importantly, when they appear before you, because they have a duty also in the dispensation of justice, because they represent clients, which form part of their or came to their clinical legal education program. So insofar as the other findings of the court is concerned, they found that the respondent judge unduly intervened in the presentation of evidence. So, but our law students may be lacking in experience and skills, but it doesn't mean that the judge should just help him out by doing the work for him. That's not what we are asking from our judges. What we are asking is for them to guide them, without coaching them or without providing them advice that would end up as being biased and a ground for the judge to inhibit. Excuse me. So in this particular case, again, the judge was found guilty of conduct unbecoming a judge and fined 7,500 pesos. So take note, twice actually, because I violated the Code of Judicial Conduct and then violated the Code of Professional Responsibility. Again, take note. That's how difficult the job of a judge is, because like I said, we have two codes that cover us. Okay? So finally, this case of attorneys Rowena Guanzon and Pearl Montesino. Rowena Guanzon is presently the commissioner of COMELEC. So she used to appear before Judge Rufon of Bacolod City, RTC Bacolod City, and they were handling, of course, a case involving, of course, women. So in this particular case, both attorneys Guanzon and Montesino charged, of course, Judge Rufon of violating the rule on gender fair language. And because in one hearing, because of the use of foul or obscene and discriminatory language, and even discriminated against women litigants, ewan ko kung women hater ang woman hater ang dating ni Judge Rufon sa kanila, no? But you know, I got to meet Judge Rufon when I was a judge. I know him. Medyo Kastila, no, ang dating, no, ang features. I don't know, perhaps because of that, medyo iba siguro ang kanyang upbringing, no. He has retired a long time ago, but like I said, no, perhaps his behavior may be brought about by you know, those times, no, when you know, there was a different attitude perhaps, no, regarding gender sensitivity. So in one hearing, Judge Rufon, no, actually in the presence of so many people, referred to one of the parties and told him, because her, no, that because perhaps it involves an annulment case, no, that next time you see your husband, according to Judge Rufon, no, and based on the allegation in the complaint, he was quoted as saying that next time, and I quote, no, next time you see your husband, open your arms and legs, end of quote. So para bang you know, para bang blame ano pa yon, no, blame throwing pa yon, no, to her, no, para bang yung what has happened, if you heard the news about this stewardess na, you know, who unfortunately was killed or died, no, on New Year's Day, no, kasi morning na of New Year of January 1, and there are some quarters who are saying that you know, the reason why it happened is because perhaps because of she allowed it, no, which is unfair, which is really unfair. Anyway, so that more or less was the tenor of the charge against Judge Rufon, and the court found that, of course, one, a judge holds a position in the community that is looked up to with honor and privilege. So you know, you cannot just utter those kinds of things and think that you can get away with it simply because you are a judge. No, hindi naman pwede yun. And the court said that we cannot overemphasize that no position is more demanding as regards moral righteousness and uprightness of any individual than a seat in the bench, on the bench, no, for obvious reasons. No, it's not easy to become a member of the bench, to become a judge, because you have to go through, of course, the Judicial and Bar Council. They have to make a scrutiny of you. I mean, vet you, no, in other words. And when you're shortlisted, if you get shortlisted, then you have to go through another screening, no, from the office of the president. And then when you're appointed, then that's a time, you know, that you will come to realize how difficult it is. No, there are responsibilities that go with being appointed as a judge, and this is something that Judge Rufon is being reminded of. And of course, another finding of the court is the court is that the judge, no, the respondent judge, Judge Rufon, cannot utter in open court intemperate and obscene language injurious to the sensitivity and feelings of complainants who are all women. So take note, more or less, that statement was found, no, to be so insensitive that it merited, you know, finding respondent Judge Rufon guilty of vulgar and unbecoming conduct, and was fined, you know, 5,000 pesos for that. So I guess that's about it. That's more or less what I want to share with all of you insofar as judicial attitude towards law student practitioners is concerned. I hope that one way or the other, I was able to share with you things, no, that would help, no, as we go along in the, you know, allowing and authorizing law students to practice before our courts, depending on the level, no, of the certifications being issued to them. And of course, for all the lawyers and all the judges, I hope now you realize how important it is for you to see to it that not only are these certifications respected and recognized, but also you have to take into account that law students, law student practitioners need mentoring, no, without being condescending of them. But the whole point is to just help them, no, and inspire them to finish law, to be inspired, no, to really pursue, no, a law degree and become eventually full-fledged members of the bar. So I guess, like I said, that's about it. Thank you again to the Legal Education Board for allowing me, no, for inviting me and allowing me to make this presentation for all of you in connection with, you know, the implementation of the revised Rule 138A of the Rules of Court. So with that, maraming salamat sa inyong lahat, and how I wish I could, you know, entertain some questions or even some comments from all of you. But like I said, this is really different, no? The kind of thing that we have to, you know, adapt to right now. We have to do a lot of things online, so it's not something personal nowadays, no? So, but please, if there's, if you wish to ask anything, I can give you my cell phone number, 0908-867-4698. You can just text me if for anything that you might be of interest, for anything that might be of interest to you, no, in connection with my presentation. So maraming salamat to the Asia Foundation, which is of course supporting this particular program of the Legal Education Board, and to the U.S. Department of State, International Narcotics and Law Enforcement Affairs, and of course to the Philippine Association of Law Schools. I congratulate all of you for this program, and I hope that you be successful, no, insofar as providing the much needed, you know, information needed by our law students and those who will be allowed, no, to engage in law student practice. So again, maraming salamat. Mabuhay po kayo lahat.